Hello again. Welcome to this second of a series of podcasts about financial support of children. This podcast will discuss the concept of a change of assessment in what is described as special circumstances. We will also briefly examine the limited situations in which a person may bring an application to court. Part 6A of the Child Support Assessment Act 1989 sets out an administrative process for a child support assessment to be changed in special circumstances. The term special circumstances is quite important. It is not open to a parent to simply apply to the child support agency to change the assessment because they say the assessment is unfair. Part 6A provides an administrative mechanism for assessments to be changed. Just by way of background, there is some legislative history. In the early days of the Child Support Assessment Act, the only way in which a child support assessment could be changed using special circumstances was to make an application to a court. Part 6A was inserted almost 25 years ago now to enable the process to be completed without going to court. However, the power of a court to undertake exactly the same process was not taken away. We will look briefly at the court's jurisdiction as it remains now, and it's very limited, shortly. Oddly though, Section 117 of the Child Support Assessment Act deals with the content of the application for change of assessment in special circumstances, whether or not it's a change undertaken by the child support agency or a change undertaken by a court. When it is undertaken by a court, the same process is called a departure order. Now, even though the content is exactly the same and the outcome would be exactly the same, the two different terms are used. The Child Support Agency has taken the very complicated provisions of Section 117 and reduced them down to 10 plain English reasons. If someone applies for a change of assessment, they must nominate a reason and provide appropriate financial information in support. This application is lodged with the Child Support Agency. Section 98(S) of the Child Support Assessment Act sets out the power of the registrar, and for this course just be aware that Child Support Registrar means a senior case officer or an appropriate person within the Child Support Agency. I am content with the use of the word registrar or senior case officer or Child Support Agency. The powers set out in Section 98(S) are quite extensive, but for our purposes the key power is the power to set a new annual rate of child support in substitution for an assessment of child support. I put on this slide for you an extract from a couple of pages of the application to change an assessment in special circumstances, plus the URL for the form if you wanted to take a more detailed look about how these applications work. It might assist with your understanding if you can see how the applications work in practice. Let's look at some procedural components. The Child Support Agency may make a determination for future child support periods or for periods up to 18 months before the date on which the application is lodged. In other words, they can go back in time and determine the amount of child support that might have been payable over a particular past child support period. This is set out in Section 98(B) of the Child Support Assessment Act. The responding party has a right to be provided with the relevant documentation and has a right of reply. Section 98(G) Child Support Assessment Act. The rules of evidence do not apply, and no one is entitled to legal representation, although that doesn't mean they can't get legal advice. Section 98(H) of the same Act. Section 98(S) sets out that the person making the determination within the Child Support Agency must give reasons for making that determination. In order to be successful in an application under Part 6A, the applicant has to demonstrate each of the matters contained in Section 98(C) Child Support Assessment Act. They are, firstly, that a ground, that is a reason, for departure or change exists. If this ground or reason is made out, then the application can proceed further. Without this ground or reason being established, the application must fail. Second, an applicant must show that it is just and equitable for a change of assessment to take place. Just so that you are aware, the concept of just and equitable in this section has no relationship to the concept of a just and equitable property settlement, which is a concept you'll be studying later in your course. Third, the applicant must demonstrate that the change is otherwise proper. Let's look in detail at each of those three elements. The Child Support Assessment Act is available via a direct link on your learning page for this module. Section 117 of the Child Support Assessment Act is also set out in full at pages 437 to 441 of Professor Parkinson's prescribed casebook. In an exam context, you would be expected to refer to the relevant subsections of Section 117 and not to the 10 reasons produced by the Child Support Agency. The reasons, though, are good to look at because they provide some plain English understanding of the circumstances in which a change of assessment may be warranted. Right now, you can see the first 5, which relate to expenses concerning spending time with a child, special needs of a child, education or training of a child, about which we shall look at some cases shortly, and other financial circumstances. The remaining 5 reasons include high childcare costs, the income, earning capacity and financial resources of the parents or of the child, and a responsibility to support a resident child, that is, not a biological child of the payer. The grounds are set out in Section 117, subsection 2, and at pages 437 to 438 of the casebook. You need to examine the subsections very carefully. The drafting is, in one word or phrase, less than optimal. For example, the cases we'll be examining shortly about private schooling fall under Section 117, subsection 2b, Roman 2. Special needs fall under 117(2)b, Roman 1, subparagraph IA. Again, I recommend you take a good look at the legislation directly to make sure that your citations are correct. Let's assume, for the time being, that a ground or reason has been established. It is then a matter of considering all of the relevant factors in Section 117, subsection 4. These are summarised on the slide in front of you, but include the financial circumstances of each party, and in particular the hardship that would be caused if the decision were made or was not made. In an exam context, you would be expected to cite the relevant subsections of 117, subsection 4 and apply the relevant factors to the case. The third and final step for the decision maker is to consider the impact of the decision on the Commonwealth, and again to consider the nature of a duty of a parent to maintain a child. While there may not often be specific facts that relate to this area, it is important to demonstrate your knowledge of this final step and note in appropriate cases that it doesn't apply. The flowchart on page 546 of your prescribed textbook sets out a suggested approach to advising in relation to child support in special circumstances. This may help you in answering questions and or preparing for your exam to ensure that you have addressed all of the relevant matters. There are 2 issues that are going to be examined in a moment using some case law. They are the issues of private schooling and earning capacity. First, consider this fact scenario. 2 parents are cohabiting, and during that time their child or children attend a state school. Subsequent to separation, one parent enrolls the child or children in a private school without consulting with the other. In those circumstances, is the other parent liable to pay some or all of the costs towards private schooling? It is exactly those facts that occurred in the case of paradigm that is on the slide in front of you. Relevantly for us, the mother enrolled the youngest child in a private school without any consultation with the husband. The key principle from Paradigm's case is this: as a general rule, a party should not be obliged to contribute towards private school fees unless he or she has consented to do so, or unless he or she has consented, that is in the past, to the child attending that school. On the other hand, there may be cases where it would be appropriate for a party to be compelled to contribute towards private school fees, even though he or she had not been consulted upon the matter or had not consented to the child attending a private school. The next case, from 1986, of Me and Ferguson, narrows the point a little. It does repeat the statement that a parent is not liable unless there is consent, but also notes that if there are reasons relating to a child's welfare, or let's say nowadays a child's best interests, that dictate attendance at a private school, and I add, for example, religious beliefs of the entire family, that would dictate attendance at such a school. Let's turn to the issue of earning capacity. The next case I want to address is that of DJM and JLM. In this case, the husband had left a fairly lucrative consultancy position to move into academia. You'll note that the term earning capacity appears at least twice in section 117. It appears in section 117.2 as part of a ground or grounds or reason to change a child support assessment in special circumstances, and it again appears in section 117 subsection 4 as one of the matters to take into account in determining the justice and equity of the proposed change of assessment. So there is an issue, and the issue was discussed in DJM and JLM, about what earning capacity actually means. Having considered some overseas decisions, the full court decided that earning capacity had three elements: the ability to work, including qualifications to work, the willingness to work, and an opportunity to work. Deciding earning capacity can be particularly important where, using a hypothetical example, a person decides either to give up work completely or not earn intentionally as much as before as a means to avoid their child support obligations. A change in assessment could then be made to calculate child support based on that parent's higher earning capacity, not their actual earnings as they may stand at that time. Next is an important matter. There has been a change in the law since your prescribed text was written. At pages 548 to 549 of your prescribed text is a statement about section 116 of the Child Support Assessment Act. In 2015, that section was changed. In order for a court to have jurisdiction to hear a departure order application, then that first ground, that is, that there is another application on foot and in the discretion of the court it would be appropriate to hear the application, still exists. However, previously the legislation provided that if the Child Support Agency, or what is known as an objections officer, decided that the case was too complex, then the matter could go straight to court. That ability has now been lost. If the Child Support Agency decides that an application is too complex, it will instead be redirected to the Administrative Appeals Tribunal rather than to a court. This brings us to the end of the second podcast. Next, I will take you through the provisions of the Child Support Assessment Act in relation to agreements, and also examine the residual jurisdiction of the court under the Family Law Act for certain types of child maintenance. Thanks for listening. Bye for now.